Okay, so we're going to continue with our discussion about the things that you need to understand about ERISA welfare benefits. And those benefits can be provided pursuant to a plan or a policy. We've talked about this or alluded to it earlier. And number 4 is there's no jury trial. You don't have the right to appear in front of your peers and present your case and have a judge decide or the jury decide you're entitled to entitlement to benefits. You just don't have a trial. You don't get to appear. Your doctors don't get to appear. It's all completely different than a personal injury case, a workers' compensation case, or any other kind of case. The judge is the one who gets to decide the case. And so, number 5, the cases are decided on what's called a motion for summary judgment using the applicable standard of review. So every plan or policy will provide for the standard of review, and either it's arbitrary and capricious or an abusive discretion standard, which is the same thing. And that standard is deferential to the decision made by the insurance company. And generally, it can only be overturned if there's no reasonable basis for the decision or there's no conflict of interest in the decision-making process. Now, as an ERISA disability attorney, I would like to see a policy that calls for a de novo review. And there are still some of those running around. But in a de novo review, the judge gets to say nuts to the insurance company and reach an independent decision based on their own review of the file. Number 6, what you get if you win is not really a win. What on earth does that mean? Look, if you are successful in overturning a claims denial, and we're successful, the federal court can award the benefits claimed through the date of the denial, or they can send the claim back to the insurance company for another review. This is called a remand, but it's really giving the carrier a second bite at the claims denial. And more often than not, they get the denial right the second time. So you can win, but you can lose. Number 7, the games begin again, even if you win. So if the court awards benefits, that award can result in the payment of back due benefits. And depending on the jurisdiction and the judge, maybe you can get some interest and maybe you'll get attorney's fees. But the practical result is that you've been put back on claim. And guess what? The games begin again. So the reality is that the majority of ERISA benefit cases are settled because the prospect of being successful in federal court on appeal to or appeal to the circuit court just isn't the best, particularly if you've got an arbitrary and capricious standard of review. So what I want you to do is to remember these 7 things. Number 1, ERISA preempts any state law remedies. 2, ERISA benefit litigation is unlike most litigation anybody has ever heard of. Discovery is limited in an ERISA case. 4, there's no jury trial. Cases are decided on a motion for summary judgment. 6, a win is not a win. And number 7, the games begin again. I think you owe it to yourself to have your case handled by an ERISA expert who can explain to you the wonderful world of ERISA disability claims, appeals, and litigation. In my next segment, we're going to do some more myth busting. I love busting myths. And the myth is, if the disability insurance carrier sends you an activity of daily living form to complete, it's because they are so sincerely interested in how your disabling symptoms impact what you do every day and why you should be paid your disability benefits now.